Supreme Court allowed the appeal in the matter of AMRESH SHRIVASTAVA versus State of Madhya Pradesh and set aside the judgment passed by Division Bench of the High Court, thereby restoring order of the single judge. Facts in the instant case were that the appellant was appointed as Naib Tehsildar on 15 June 1981 and was promoted to Tehsildar on 31 December 1991. Between July 1993 and September 1998, he was posted as Tehsildar in Gwalior district where he performed various functions including quasi-judicial duties. Application filed by Kuber Singh and Madhav Singh, sons of Suraj Singh, for settlement of land measuring 1.500 hectare of survey number 1123 situated in village Baru. After issuing notice, no objection were received. Gram Panchayat was consulted and passed resolutions stating that applicants were cultivating land and had no objections to settlement in their favor. Following procedure as prescribed under rules as also statement of Patwari, said application was allowed subject to conditions. Appellant as a quasi-judicial authority passed land settlement order dated 26 June 1997 and it was not challenged and same attained finality. After significant delay, show cause notice dated 21 September was issued to appellant by collector of district Gwalior. The notice alleged that land settlement was granted to ineligible persons in an illegal manner, contrary to the rules. It further stated that mutation order led to the land being sold, which originally vested in state government, causing undue benefit to parties due to negligence and carelessness in duty. Two aspects which needed to be considered were whether the charge sheet issued to appellant by respondent state would fall within scope of observation that had been carved out by the court in K.K. Dhawan case, whether inordinate unexplained delay in issuance of charge sheet, in this case 14 years, would in itself be a ground for quashing the charge sheet issued to appellant. In present case, Supreme Court said, we are of considered view that charges against appellant in charge sheet fall under category of wrongful order which does not appear to have been influenced by extraneous factors or any form of gratification. It appears that order had been passed in good faith without indication of dishonesty. The facts outlined in show cause notice do not suggest any such impropriety. The power exercised by the appellant in his capacity as a Tehsildar while passing order of land settlement order cannot be considered of nature that would warrant disciplinary proceedings against him. Decision relied upon by counsel for appellant supported this view. Consequently, first question was answered in favor of appellant. As to second question regarding whether delay was a ground to stop departmental proceedings at stage of charge sheet itself, suffice it to say that this varies from case to case. However, in instant case where there was unexplained inordinate delay in initiating departmental proceedings despite alleged misconduct being within knowledge of department but still no departmental proceedings were initiated, answer must go in favor of the employee. However, there may be cases where department was not aware of such irregularities or misconduct which was of nature that was indicative based on material consideration of factors other than merit such as extraneous influences and gratifications. In such cases, such a delay by itself would not be valid ground to scuttle initiation of the process of departmental proceedings. Reference in this regard was made to the decision of the court in state of Madhya Pradesh versus Bani Singh and another, wherein court noted that there was no reason to interfere with quashing as disciplinary proceedings were initiated after 12 years of delay. A reference was also made to decision of court in P.V. Mahadevan versus M.D. Tamil Nadu Housing Board, where it had been reiterated that continuing departmental proceedings after undue delay would be unjust, causing unnecessary mental distress and damaging reputation of the employee for mistakes committed by the department in initiating disciplinary proceedings. In view of the above, present appeal was allowed.